Good afternoon, everybody, and thank you for joining us in the first part of our webinar series. Today, we will be speaking on recent developments in False Claims Act litigation and some parallel statutes. Today the presentation is by David Pivnick and myself, Barnett. Advancing the slides, David is a partner in our McGuireWoods Business and Securities Litigation Department. He is also the co-chair of McGuireWoods Healthcare and Life Sciences Industry Team. David has extensive experience litigating FCA and related actions throughout the nation and conducting internal investigations and responding to civil investigative demands and subpoenas from the government. He is also the co-founder, editor-in-chief, and contributing author to the McGuireWoods False Claims Act blog, which is the FCA Insider. And then my name is Brett Barnett. I am an associate in the Business and Securities Litigation Department, and like David, my practice focuses exclusively on healthcare litigation with a heavy emphasis on fraud and abuse cases. Like my practice mirrors David's in many respects. We litigate the same type of cases. We work together on defending against False Claims Act cases and conducting investigations. And with David, I am the co-founder of the FCA Insider and one of the editors and also a contributing author. Before we jump into the slides, I want to just give an overview as to what we're going to cover today. We plan on first just giving a quick introductory primer on what the False Claims Act is, what the current statistics are from the DOJ, because I think that gives a good indication as to where the hotbeds of activity are, what the DOJ is looking at and interested in, touching on some of the key cases that we've seen come out over the past couple of years, some of the DOJ's recent pronouncements on advancing and prosecuting FCA cases, and then wrapping up with just, I think, some helpful primers, reminders, tips on responding to a civil investigative demand and on dealing with a potential exit employee departure and conducting exit interviews properly. And so starting off, just as a brief introduction to anyone that's not familiar, the False Claims Act is the government's primary tool for combating fraud. It's initiated largely, well, most of the cases are advanced by whistleblowers that are called relators in the FCA context. Relators can be anybody from an insider employee to a competitor to somebody that spends time mining the CMS data and markets just to see if they can find something that they think turns up as a False Claims Act case. There are very few limitations on who can be a relator, other than other than someone's counsel. There's actually been cases in the past couple of years where someone's former counsel has tried to become a whistleblower and turn on their former client and bring an FCA case. Courts have rightly rejected that and thrown those cases out immediately. The FCA was initially enacted back in 1863. It was referred to as Lincoln's Law. It was a way initially to combat government contracting fraud during the Civil War. It sat dormant for, very seldomly used for about 150 years. And then there was a series of amendments that started in the 80s and then in 2009 and then more recently in the past couple of years that have really broadened its scope, given the FCA some teeth and built in some incentives for relators to file suits and their avenues for doing so. And over the past decade or so, we've just seen a tremendous uptick, I'm sure many of the attendees on this call know, in the amount of recovery that the DOJ's amounts of recovery on an annual basis. It's billions of dollars every year. And part of that increase is, over the past couple of years, is attributable to the fact that starting a couple of years ago, the government increased the per claim penalty from where it had been to now adjusted on a current basis, on an annual basis, to where it's now currently at $11,665 to $22,331. And so, in addition to your amount, your actual claim damages, which are then trebled under the FCA, there is a per claim penalty that ranges between approximately $11,000 and $22,000. So those totals add up and give the government plenty of grounds to find ample recovery of that. And I know Dave is going to walk through some of the DOJ's numbers over the past year.
Perfect. Thanks, Brett. Appreciate the introduction, and thank you everyone who's joining us. Want to focus a little bit on the numbers from the last year that you all can see on the slide, but also talk about the trends and what we're really seeing, because I think there's a real practical impact and consideration there. So the general takeaway is the numbers in the false claims world continue to be staggering. The government is spending a significant amount of money on fraud enforcement, and particularly on healthcare fraud and abuse enforcement. And that hasn't really changed, depending on the administration or whether it's a Democrat or Republican in office. And I don't expect it to change, when President Biden or President-elect Biden takes office in January. This is a situation where over the last 6 years of time, from 2014 to 2019, those are the highest 6 years of government recovery ever. So the government is making more money each year now than it previously made before. The high watermark was $4.9 billion a few years ago. The government hasn't got nearly that high again. It tended to be more in the $3 to $3.5 billion range, but those are obviously still staggering amounts of money that the government is recovering on an annual basis. And I think it's telling, because when the government is recovering that much money, and the government fraud enforcement budget typically, it's been going up about 10% annually for the last several years, but it's in the mid hundreds of millions of dollars. I'd have to look, but my guess is it's around 650 million right now. The government's getting a substantial return on investment at the federal level on fraud and abuse enforcement. And the reality is those same numbers bear out, and there's a consistency in that number and that math at the state level. So one of the things that I think is going to continue to drive enforcement is the government gets a significant ROI, and in a time when there's lots of concern as a matter of budgeting, both at the federal level, but frankly more pressingly at the state level, this is a place where governments can help right-sizing their budget and making things work from a fiscal perspective without being controversial. Other ways of adjusting budgets, if you cut Medicare reimbursement or spending on healthcare, there's going to be lots of people, physician and lobbying groups, who are going to be upset about that. If you increase taxes, people get upset. There's not really a pro-fraud lobby, so to speak. I guess some people might take political umbrage with that, but as a more baseline statement, no one is really pro-fraud. And so there's a real opportunity for the government to continue to make money and rooting out fraud. And the reality is the results bear out that spending by the government. And the DOJ is spending it, by the way, not just in conducting its own investigations. The DOJ does a very robust amount of statistical analysis and digging into the numbers and trying to figure out where there are outliers from the norm that they might want to send a subpoena or some investigative demand to. But on top of that, the government is seeing an increase in the number of whistleblower cases that are filed, and I'll talk about that in a second, and also is intervening far more often. So the government, over the last decade, if we looked at it from 2008 to 2019, the government intervenes. So in other words, it takes a case that a whistleblower filed and decides to take over that case itself and to pursue it on behalf of the government directly. So DOJ would then be prosecuting the case. The government exercises its right to do that, in the neighborhood of 21 to 24% of the time. And that's been pretty consistent over the last 12 years. What's changed, though, and I think it's a pretty significant change in impact, is the number of qui tam lawsuits that were filed, in 2008, for example, is in the neighborhood of 350 to 400 such cases. So when the government is now intervening in approximately the same percentage, but the number of whistleblower cases that are filed on an annual basis has effectively doubled, that means that the government is intervening and taking over approximately 2 times as many cases. So the government is taking a much more active role. And as noted in the middle bullet here, a significant portion of that is in the healthcare space. It really doesn't matter what year you look at. Any time realistically you're digging into the data, and whether you look at it by the number of case filings, the instances where the government intervenes, total dollars recovered, the government is spending the majority of its time, and the majority of the money is tied to instances of healthcare fraud as compared to other industries that are facing scrutiny under the False Claims Act, defense and mortgage being 2 and 3. But again, healthcare comprises, depending on the year, but 60 to 70% is the range that healthcare typically finds itself in. And then before we move to the next slide, I'll just note the number of FCA suits that were filed last year is significant. 782 is one of the highest years that we've seen to date. And, 4 out of 5 of every one of those cases that was filed is a whistleblower lawsuit. And I think that's important here, as we deal with a tumultuous time in terms of economic challenges, the impact of the pandemic, layoffs and increases in unemployment. Those are indicators of litigation rising generally, and we've seen that impact in the connection of the False Claims Act before. So in 2008, when the financial crisis hit, that was a significant cause of a significant increase in false claims cases. And some of it was cases relating to the banks and mortgages, but really it was an overall increase. And what we find is when people are getting laid off or they just have financial issues, they start to look at ways they can potentially recover money. And if you lay off employees who are then going to go to a labor and employment attorney thinking they might have a harassment case or a discrimination case, and the attorney they're speaking to says, well, did you see any compliance issues? Is there anything else you can give me? What else can we pick at? What else can we file? These cases can start to spiral and expand. And what was a small case focused on, wrongful discharge, for example, or unpaid wages can grow. And so I think we're going to see a rise in the number of filings next year. I think we're going to see that this year there was a rise, and I think it's going to be a pretty steady flow where for the next several years the numbers are pretty significant in terms of key TAM filings. With that in mind, and with my comments a couple minutes ago that healthcare is a pretty constant focus of the DOJ, I think it's worth highlighting the main areas on which the government is focused. And so the biggest one, and we've referenced big pharma here, but notwithstanding we've given some examples of where that comes up, I can pinpoint that further. I mean, both on the civil side of DOJ and the criminal side of DOJ, the respective chiefs in DC on those sides, at the National Healthcare Fraud Conference last year, which at this point feels like decades ago, but both of them made it clear opioid abuse and the opioid crisis is number one with a bullet on their list for enforcement. And there's nothing that I've seen since that suggests to me that that's going to change. And I think pharmaceutical companies are going to continue to be part of that enforcement effort, and, kickback schemes and marketing issues, things of that nature are going to continue to come up. And obviously we've seen some significant cases in that space over the last year and a bit, the last few years. But I think it's going to be broader than that. I think one of the reasons the opioid crisis is going to continue getting so much attention from DOJ is because it's so multifaceted. There's various cases. It could be pharmaceutical companies who are being pursued. It could be investors in big pharma. It could be physicians who are overprescribing, who are giving automatic refills, who are selling prescription pads or selling prescriptions generally. All kinds of improprieties on that front. It could be people, who are selling narcotics illegally, just, bottom line, drug sales. I mean, there's lots of issues and risk areas there. It could be marketing arrangements. Generally, and it could be labs where the government has concerns that labs are acting improperly. And so I think we're going to see a lot more enforcement there, and the government is certainly incredibly focused on it. And I would expect that will continue, not just because I think there's a lot for the government to pursue, but also, frankly, everyone is familiar with the opioid crisis. It's gotten significant national attention. And unlike many of the other areas of fraud and abuse enforcement in which the government participates, where they're trying to protect the government fisc, and I'm certainly not going to suggest that's not important, but at the end of the day, it's sort of a straight up and down financial consideration. In connection with the opioid crisis, it goes a little deeper than that. There's lives at stake. People are getting hurt. People are, getting hooked on drugs and putting themselves and others at risk. And so I think the government also has, a bigger story to tell, which I do think matters to a lot of prosecutors. We mentioned labs here, and I just spoke about that. There's a lot of follow-up on laboratory testing, whether the testing is necessary, whether it's being properly billed, whether it's being provided at the correct locations. And one other industry that I think DOJ has been focused on and has indicated a focus in the last few years consistently is skilled nursing facilities and home health. And I think it will be interesting to see if that priority both continues and potentially expands in light of the pandemic, because obviously more people are currently receiving, telehealth, telemedicine appointments and other approaches to care that could potentially be more ripe for abuse. And certainly I hope that, all of my clients, and I have every expectation all of my clients are doing things the right way, but I think that's an area that's going to get increased government scrutiny. And then the last one that I'll touch on the slide is private equity. And I think that's a controversial one because I think, people hear that and get concerned and have a visceral reaction of, there's nothing wrong with investing in healthcare. There's nothing wrong with making money in healthcare. And I echo that. I feel very strongly about that, in fact, and the government hasn't done anything to prevent that. I have not seen cases, and I don't expect to see cases that are brought against private equity participants in the healthcare space, PE funds or their executives, just by virtue of the fact they've invested in healthcare companies or are making money in the healthcare space. Where I think the concern comes up and where the cases I've seen have sort of focused is where the private equity fund is itself involved in some way in the impropriety. Either the private equity fund has actually implemented the aspect of the business that the government is concerned about, whether it's a compensation structure or a modality or an expansion of the business or marketing, where it's something that the PE fund actually managed, where the PE fund has had control of or significant representation on the board of directors, was aware of an issue and didn't take requisite steps to, cut it short or in fact continued it, or in instances where the PE fund may have, tried to be overly aggressive in buying its stake, knowing that there were problems that it, could take advantage of a price point, but not then correcting those issues afterwards. So there was knowledge and a benefit to the PE fund, but not corrective action. So, I mean, these are pratfalls to me that can be avoided by running the business and focusing on compliance while still investing in healthcare and turning a healthy, compliant legal profit. But I think there are things that need to be considered by PE funds while investing to make sure that things are being done properly to avoid, stepping in the mud here. And particularly where the whistleblower bar is a very sophisticated bar and they're active and they pursue these cases, I think it's a reminder to make sure that you're being diligent in diligence, frankly, and rooting out problems. And if you identify things, it doesn't necessarily mean you have to turn down every deal that has some hair on it, but I think it means you have to really think about what the impact's going to be, how you're going to clean up those potential problems and move the business forward. And then briefly, as I mentioned earlier, I think in light of what's going on in the economy, we're going to see a continued emphasis on fraud enforcement, and I expect to see a lot of cases that come out. I think that's going to take a few different forms. There's some good news that I've seen a little bit more flexibility from the Department of Justice and OIG in connection with settlements and working out payment plans and potentially staggering payments if there's cash shortfalls that have been caused by businesses being closed or impacted by COVID. We've also seen a little bit more flexibility than I've seen in the past with OIG in terms of enforcement issues. And I don't mean that they're letting things slide, but more, extending timeframes or working with people who are under corporate integrity agreement to allow a practical, measured response in light of the pandemic and impacts on business. But I think the opposite of that is going to be we're going to see some enforcement. And I think some of it is going to be looking at the use of, PPP funds and CARES Act funds and seeing how that money was used and if there were, if things were done in a compliant manner or not, seeing if the forms were completed correctly and certified accurately. So I expect to see some action there. And I think the price gouging cases, both at the federal and state level, is something that we're going to see, with growing frequency going forward. And again, much like the opioid item, it's a place where there's significant dollars that are potentially at risk, but also the government has a very favorable story to tell, which I do think matters to prosecutors who want to feel like they're making the world a better place, not just trying to get money for the government fisc. I don't think that's why most prosecutors, join the Department of Justice. And so I think there is a sincere element where, being able to go after folks who are taking advantage of people suffering during a pandemic, I think that is the exact type of fraud and abuse that DOJ prides itself on trying to root out, not just a monetary issue. So with that, I'll turn it back to Brad.
Thank you, David. And so we wanted to turn to just some of the main theories of law that we're seeing advanced in some of the key cases that have come out over the past couple of years. I know in a continuing trend from the implied certification theory, which is a topic that we've touched on when we're giving similar presentations over the past couple of years, we're still seeing an outpouring of case law that is challenging or trying to test the bounds and meters of the implied certification theory. In short, the implied certification theory stands for the proposition that every time a provider or payee submits a claim to the government, there is an implied certification that they're in compliance with all contractual, statutory, regulatory provisions and obligations, and that if that is false, they have given rise, their action and conduct has given rise to FCA liability. Prior to the Supreme Court's decision in Escobar back in 2016, there was a circuit split as to whether the implied certification theory was even viable, with the Seventh Circuit, I think, being the lead proponent of courts saying, no, it is not. Only express certification theories, which is that there is something false on the claim form itself, is viable. And with Escobar, there was a seismic shift in that, where the Supreme Court announced in no uncertain terms that yes, the implied certification theory is a viable theory of liability under the False Claims Act, but in order for it to be actionable, it needs to be material. And so it needs to have made an influence on the government's decision to pay a claim. And so over the past 4 years, we have seen an increase in the number of cases that are being filed based off of an implied certification theory, and then two, a outpouring of opinions concerning what that means, what the implied certification theory stands for, and most importantly for here, what does it mean for a claim to be material? And I think a great case study on how this materiality standard is still being developed is highlighted in the Ruck versus Sales rehabilitation case. And so Ruck was a case that back in 2018, it concerned a nursing home or rehabilitation center that had been accused of various violations with their upcoding and just with false billing. And largely it was that providers were lying about or misrepresenting how much time they'd spent on therapy. They were upcoding for charges for services that were not actually provided. And it went to trial in Florida in 2018, I believe, or maybe late 2017. And the jury ruled in favor of the relators and against the defendant, and a $340 million verdict was awarded against the defendants. The defendants moved for judgment as a matter of law, arguing that none of their purported misstatements were material. Everything was simply either a clerical error or it was a documentation issue, which is not material, and the court agreed. And the district court threw out the $340 million verdict and ruled in favor of the defendants. It obviously went up on appeal. And the 11th Circuit, about 4 or 5 months ago, in June 2020, reversed in part on the district court's opinion and reinstated an $85 million award against the defendants. And in doing so, the 11th Circuit gave its own interpretation and explanation of the materiality standard and its application to this case. It's worth the read for just the converging opinions on what can be material and what the district court considered to be just a sloppy paperwork error or a regulatory noncompliance, which courts are in agreement is not material under the FCA, that a regulatory violation or something that is just a pure like paperwork issue, that doesn't impact the government's payment decision, therefore it's not material. But taking and looking at those same facts, the 11th Circuit said no, the fact that these physical therapists misrepresent or misstated the number of therapy minutes that were spent on a particular patient, the fact that they don't have documentation to support the level of care that was given to these patients, that is material. That did impact and affect the government's decision to pay the claims. Therefore, there is liability under that basis. And they reinstated the award to the extent that it pertained to Medicare dollars. They had a different take on the Medicaid dollars, which they did find was not sustained. But for the Medicare dollars, they did award, it was an $85 million judgment, and now it's back down to the district court for trebling of that amount and for an assessment of per claim penalties. So it's an interesting case just because we're seeing the development of the materiality standard and how it's changing and how its perceptions differ depending on which court and which judge is looking at it at a given time. Switching topics, but staying with key cases that have come out of the past couple of years. The last FCA case to get before the Supreme Court was Cochise Consultancy versus Hunt. And this case concerned an issue that's key to many defense claims in the FCA world, which is the statute of limitations. The standard pronouncement, or the basic easy concept of the False Claims Act statute of limitations, is that it's 6 years from the date that the claim was submitted. It's a 6-year rule, that's the easy part, and then it gets complicated, where the second part of the statute is, or 3 years from the government's knowledge of the claims, and then it dates back to 10 years from when the claims were submitted. And so it's that government knowledge prong, which if that prong is triggered with the 3 years within the government's knowledge, it allows the claims to go back 10 years as opposed to that 6 years. In Cochise versus Hunt, the key issue was whether the relator, as opposed to the government, can take advantage of that government knowledge prong to say that, well, if the government knew within 3 years of when the FCA action was brought, can I go back to those 10 years for when the claim were submitted in order for my claims to be timely? In this case, the claims would have been timely if they had access to that 10-year look-back period, but would not have been actionable if it was into the 6-year period. And what followed the majority opinion for the circuit courts, but I personally was, I think, a little surprised by it. The Supreme Court said, yes, in a non-intervened case, the relator can use and take advantage of the government's 3-year knowledge prong and then get access to that 10-year look-back period. So here, because the relator had informed the government of the basis for what was his False Claims Act case, I think it was in 2013, and then filed suit in 2016, that was less than 3 years after he disclosed it to the government, he was able to go back and take claims that dated all the way back to 2006. And so that was an important decision because I think it greatly modifies and changes some of the defenses that a lot of the FCA defense bar has been able to take advantage with or use to its advantage in statute of limitations cases. One of the more recent cases, and this is, I think, within the past couple of months, and is not an FCA case, but it's an adjunct to a new statute that has similar and shares certain commonalities with the False Claims Act that I thought was worth sharing with this group, is that in September 2020, the DOJ released a press statement or press release announcing that they had secured one of the first convictions under the Eliminating Kickbacks and Recovery Act, which I think, as David, I think, spoke to in quite some nice detail, is the government is focusing on opioid treatment and combating people that abuse both those that are addicted to opioids and those that take advantage of the reimbursements that are connected to opioid treatment. And so the EKRA was enacted in 2018. This was one of, according to the DOJ, one of the first convictions they secured with it. And what is important to note here is that whereas the AKS and the FCA pertains to government dollars or money that's paid out of the government fisc, you're getting things like EKRA that pertain to literally just all commercial insurance, all reimbursements that are received by providers or payers that are done in exchange for a kickback. And so in here, Dr. Muhammad ran a therapy clinic out of California, and it's a pretty simple arrangement. He was paying marketers kickbacks for them to go and find patients that were addicted to opioids and then to refer them to his clinics. And then they would bill the insurance companies for the opioid treatment and dependencies, and they would have a nice cycle of where the insurance would get billed hundreds of thousands of dollars, and Dr. Muhammad would pay a kickback. I think they ranged between $5,000 and $10,000 to the marketers. The marketers would then in turn give a portion of that to the actual recruiters who were on the ground trying to find those that were addicted to opioids. And so the DOJ advanced a prosecution against Dr. Muhammad and his co-conspirators. His co-conspirators were found guilty under the General Healthcare Fraud Act, which is a statute that is more widely used. But it's just interesting to see that we're getting action out of the Eliminating Kickbacks and Recovery Act. And it's an interesting way to see is that the government is advancing prosecutions against individuals that are involved in commercial insurance or schemes that involve kickbacks with commercial insurance as opposed to just your traditional anti-kickback, which is focused on government dollars. And so we saw this a couple of years ago in Texas, the Forest Hills case, where it was a group of doctors who they expressly and repeatedly made clear they do not take government dollars. They are commercial only, and therefore they should not be prosecuted under the anti-kickback statute. Well, in that case, we saw the DOJ advance what at that point in time was considered like a novel, or at least widely perceived to be a novel theory, and where they pursued a prosecution under a violation of the Travel Act, which says that as long as there is a violation of an underlying state law, you can be subject to effectively the same type of level of prosecution and scrutiny for your for kickback schemes that involve the exchange of commercial dollars as opposed to just Medicare dollars. And in that case, the government, I know, was able, and as I'm sure many of the audience know, the government was able to secure a prosecution and conviction on the vast majority of the defendants. One of the last cases I just wanted to touch on, and more of just an interesting case and something that is helpful for the FCA defense bar, is Holloway, which is a Sixth Circuit opinion that came out earlier this year. And this is just, it was a furtherance and a pronouncement of a new element or a new argument, or an argument that's not advanced in many cases, of the public disclosure bar. In Holloway, we had a relator who was a former hospital employee. She sued Heartland Hospice on the basis that it was engaged in a fraudulent scheme to keep patients in hospice care, as is pointed out in the second bullet point. Holloway didn't actually, according to the motion to dismiss briefing on this, Holloway didn't actually have knowledge of this and this happening at her employer. Instead, what she had done is that she had found that a similar suit involving the same parent company had been advanced in a different jurisdiction, and that was a scheme in which, or a case in which the relator and the relator had been able to make some traction and advance into discovery in that case. And so Holloway brought a suit saying, well, if it's happening there, it's happening to this case as well. the defendants moved to dismiss on the basis that it is the claim is prohibited under the public disclosure bar, which, amongst other things, prohibits you from bringing and advancing an FCA prosecution based on facts that are publicly disclosed, as it applies to here, in a public filing that's being advanced by the government or its agent. And the key thing for Holloway was whether an agent can be a relator, which it was in the companion case that Holloway had formed her complaint under, or whether the government's agent for all purposes needs to be the DOJ. And the Sixth Circuit, which followed the majority opinion on this, the majority of circuit courts on this, said no, for an FCA case on the public disclosure bar, the government agent can be the relator, and therefore any allegations that are being advanced based on the exact same allegations in a separate filing are barred by the public disclosure bar, and it dismissed the case without prejudice for subject to replating. And so just another interesting tool to have in the FCA defense belt, and it's one of those cases one of those doctrines where you always get to see some kind of interesting cases because they play out with very unique facts in each instance. I think with that, we're going to turn it over to David just to give some updates on the recent DOJ pronouncements.
Sure, thanks, Brett. And wanted to touch base on a couple DOJ memos that the first couple that I'm going to talk about were referred to for some period of time, frankly, as leaked memos and reviewed as things that had sort of escaped inadvertently from the government. But the government has sort of, to its credit, stepped up and owned these and proceeded to discuss them more publicly. So at this point, the Granson memo and the Brand memo, the first two I'm going to talk about, are a couple of years old, but I think they're informative and helpful in terms of thinking about, thinking about and identifying potential risk areas, and B, potentially defending false claims cases if you ever have a need to do so, which is obviously not the goal, but sometimes that happens. So the first thing, the Granson memo, again, started as a leaked memo, but it's one the government sort of doubled down on. But it was an internal memo at the Department of Justice that effectively was reminding prosecutors across the country at the Department of Justice of their dismissal power, that, ultimately, even if a whistleblower files a case on behalf of the government, not only does the government have the right to decide whether or not to intervene in the case and whether it wants to take the case over or not, but on top of that, the government has the ability to dismiss the case out from under the whistleblower. Ultimately, these cases are brought on behalf of a whistleblower, and it is on behalf of the government, by a whistleblower, and it is the government who gets to control the case and the underlying decision of whether to proceed. And so the concept of the memo was effectively DOJ instructing its attorneys across the country to think more broadly and carefully about whether dismissal was appropriate, and whether or not, instead of just declining to intervene in cases that were untenable or absurd, etc., whether or not the government should go ahead and take that affirmative step of dismissal. I think as a practical matter, I have three comments on this. One, if you talk to DOJ attorneys about this, and I certainly have, their perspective is that memo didn't change anything. We always scrutinize whether or not we should dismiss a case out from under a whistleblower. We always discuss that and analyze whether we should exercise our discretion. So it didn't really change anything. If anything, it was a reminder. And I think that's a fair thing to say. It didn't change the law, but I think there are some practical impacts despite that comment. I mean, the first is, if I get a case that truly looks frivolous, it might be one where we do reach out to the government, where we get a civil investigative demand or otherwise, and we learn about it, and strongly suggest to the government that this is one that they ought to exercise their discretion to dismiss, because it doesn't make any sense, and it is appropriate for dismissal. And I've certainly, we've engaged in those efforts for clients. I have colleagues that have done that as well, and I know other firms that have done that. I would say there's a slightly higher receptiveness to that I've seen, but I still view that generally, if the government's already declined to intervene and not exercised its discretion to dismiss, I don't typically hold out a lot of optimism that the government is then going to dismiss because I wrote a letter, but it can be worth the effort, and it's something to remind them of in terms of this is DOJ policy. The second thing is it's a reminder that DOJ is aware of the risks that exist. We had a case a few years ago where the government declined to intervene, and the lawsuit was the definition of frivolous. I mean, the lawyer who filed it, frankly, to my mind, and easy for me to say, but I don't think he understood the law he was trying to apply. And frankly, the judge agreed with Brett and I when we filed a brief that made that point, and the judge dismissed with prejudice as to the whistleblower and DOJ. And DOJ showed up and said, well, that shouldn't be with prejudice to us. We weren't involved. And I didn't even oppose DOJ's motion on that. I said, we take no opinion. That's fine, Your Honor. And the judge said, no, it's staying with prejudice. DOJ had the right to control the case unless you give me a good reason to change it. And so I think having this out there is a good reminder. I don't expect most cases are going to limit the DOJ from pursuing suit in the future, even if a whistleblower's claim is dismissed. But that is the type of risk that exists. And one of the points the Granston memo made is if DOJ doesn't actively manage its cases, whether that's by intervening or cutting off bad cases before they make bad law, they run the risk of bad decisions and bad law getting entered that's going to hinder DOJ in future. And then the third point that I'd make on this, which I think is actually the most significant change that I've seen, is I've had a few cases in the last couple of years where there was a whistleblower complaint. We didn't know that at the outset, but we subsequently learned that. We were responding to a government civil investigative demand from the Department of Justice. That's how we learned about the case. And we went in on behalf of our clients and made pitches to the DOJ. We responded fully to the CID, and then we took the time to go in and explain to the government, here's why you're barking up the wrong tree. Here's why, our client has been fully compliant and there's nothing to see here. And I've had success in the last couple of years in a couple different occasions, and in frankly, two very geographically different locations, so two different offices of DOJ, where the government declined to intervene, didn't ultimately dismiss the case, of its own accord, but went to the Relators Council affirmatively and told the Relators Council, you ought to dismiss this case because there's nothing to see here. We've dug in and you're just off the mark. And in one of those cases, I think the relator did the smart thing and dismissed voluntarily. And having worked on the other side, they were right to. They would have pursued it and they would have lost. And my client was never going to settle. So they would have got beat up by us for a period of time and lost, and it wouldn't have changed anything other than the waste of their resources. In the other one, the relator was a little bit stickier and wanted us to come in and present and sort of make the same pitch to the government that we had made to the relator. And so we did exactly that as well. And we tried to be, play open book with them because we don't want to spend our clients' time unnecessarily litigating baseless claims. I mean, winning 3 years and a bunch of money down the road is still a win, but I'd rather do things more quickly. And in that case, the relator, again, made the right decision to walk away when it became clear to them, and I think pretty quickly, that their case was simply wrong. So I think that was, the main impact that I see here is I think the government is trying to take a bit more of an active role. The brand memo is the second memo that I'll talk about, and this one I think requires a little bit less explanation and is a little bit more straightforward and creates a good defense, which is, as Brett talked about earlier, implied certification theory cases are very much a big deal and things that come up regularly right now in the false claims world. And one of the things that happens is relators, therefore, take an increasingly expansive view of what kind of underlying violation could give rise to an implied certification case. And so there are some statutes, like if you're in violation of the anti-kickback statute, it's codified that could give rise to FCA liability. What the Brand memo did is basically made it clear that if the government is pursuing claims under the False Claims Act, it should be really focused on notice and comment rulemaking. In other words, it should be focused on statutes, it should be focused on regulations, and not looking at, for example, a violation of a CMS Q&A that was posted on the website. And I've seen a case that someone brought based on a deviation from that kind of Q&A. And so I think what the Brand memo really set in place was this concept of if we're going to pursue a case at DOJ, it needs to be based on the actual law and regulations, not just on sub-regulatory guidance that may exist and may not be being followed. And so where I think this has come up is, practically speaking, this gives rise to arguments and motions to dismiss where the case is based not on statutes or regs, but on that type of sub-regulatory guidance, to remind the court and point out to the court, not only, is this grounds for dismissal, but, oh, by the way, DOJ agrees with us. And then the last thing, and this is more by way of update of an issue that will be interesting to see how it plays out as compared to one where we have, information on the practical impact. But the DOJ in the last, in this year, in 2020, has made noise about how they're going to be getting more information, looking into litigation funding. And I think that's an interesting place, because we're seeing an increasing number of FCA cases where there are litigation sponsors behind it, fronting the costs, etc. So far, DOJ has really just clarified they're going to be taking a look at that and trying to obtain more information from about the financing sources, which I think is appropriate, because they need to understand who's ultimately bringing claims and who's involved in bringing claims on behalf of the government. But I haven't seen any further positions being taken so much as digging in. But we wanted to front that because, particularly if any of you are involved in litigation finance, I think there's going to be a little bit more scrutiny coming down the pike on that. And at a minimum, questions will be asked about the source of sponsorship for relators. And with that, I'll turn it back to Brett to talk about civil investigative demands.
Yeah, thanks, David. And so just wanted to briefly touch on, I know we're coming up on the hour, and wanted to touch on something that I know David and our colleague Christina Egan will be covering during our March 18th, 2021 webinar, part of the webinar series on what to do when the government comes knocking. And this is just responding to a civil investigative demand and having the right elements and proper measures in place to do so. Without getting into too much detail on it and beating down with David, or previewing what David's already going to cover in a future webinar, I want to just say that it's very important at the outset to make sure that you have open lines of communication with the Department of Justice or whoever else would have issued the OIG, or who else could have issued the civil investigative demand. It's important to make sure that you have open lines of communication to, one, make sure that they have an understanding and expectation as to your planned level of compliance, as to what you're finding in your own internal investigation in terms of like what steps you are taking, that you've done everything that you can to preserve documents, that you are conducting custodial interviews to make sure that they understand that this is the measures that you are taking to take it serious, to track down information from the relevant custodians, and then to get an understanding from the DOJ to the extent possible, because they are often tight-lipped and often unwilling to share information voluntarily unless needed, or they can use it to their advantage or benefit, regarding what are they actually looking for, what is your client's role, or what is your alleged role in what they're looking into, and then what is their expected timing, and whether there is or is not an underlying PTAM action to which they're investigating this, or is this something that is being brought by the DOJ initially? Just because I think that all helps frame and set out what you're planning to do with your response, how you're going to put together your presentation. Are you going to be looking to evaluate who the potential whistleblowers are and figure out whether they have credible information, or if there's ways to attack their credibility, or if it's the DOJ, where is their source of information and what are they looking for in order to address the concerns that they have found? The overall just takeaways from this, without diving into it too far, is that it's something that needs to be deliberate, it needs to be proactive, and it's something that needs to be front and center for clients, which I know as often it is, particularly in times like now where we have time constraints and there are limited resources. It's something that though does need to go to the front and center, and they do need to have dedicated resources to it, because these are time intensive, they are serious, and they are something that needs to be responded to with all promptness and with all deliberateness, to make sure that there's nothing coloring the government's impression that you're withholding information or that you're slow rolling on this, because the last thing that you want to be doing is getting a phone call hearing that the government's decided instead just to move forward with executing a search warrant, or has decided that they're just going to unseal the case because you're failing to engage in what can sometimes be a collaborative give and take process to try to dissuade the government from either proceeding with an action or from intervening. With that, I know I'm going to turn it over to David, and we're going to wrap up with what to do with an employee that's leaving.
Perfect. Thanks, Brett. And we will, I'll wrap this up relatively briefly. I think, there's a couple main takeaways. And again, I think particularly in a challenging economy where there's going to be more employee turnover than, I think businesses might typically see, in more stable times, I think it's particularly important to be diligent and careful when complaints are raised internally by employees or where employees depart. And I think the biggest takeaway, if you have an internal complaint, I think the biggest takeaway is really a simple one, which is take every complaint seriously and deal with it. And sometimes that could mean you get a serious complaint, you realize there's a potential issue, and a robust investigation is required, and it may need meaningful activity in order to correct a potential problem. It could be an investigation that comes in, or a complaint that comes in that, on its face, one look tells you that the individual making the complaint doesn't know what the heck they're talking about. I think the starting point needs to be the same. You need to figure out how real the concern is, and you need to address it. And so I think, making sure that there's a methodology for employees to raise concerns internally is important. It's important both to ensure that where concerns do exist, people have a way to bring them to the company's intention, and then you can address them. If people feel unheard or think there's not a way for them to address sincerely held concerns, they're going to either go to the government or to an attorney to escalate. So, not that we're discouraging people from doing that per se, but we want the company to hear about things first and have an opportunity to correct things, especially if it was just an inadvertent issue. Having a plan when claims come in, making sure your compliance department or your general counsel, whoever is going to be handling that, is going to have a plan of the investigation, that you're going to conduct an investigation. And that doesn't mean in every instance you need to retain outside counsel and spend hundreds of thousands of dollars interviewing everybody that's there. It means looking into every issue and figuring out on a case-by-case basis what's required here. And if a real investigation is needed, having a plan to accomplish just that. If a complaint comes in and it's clear someone doesn't understand, then I would address that. If the complaint's not anonymous, I would try and follow up with the person who raises it to make sure that you're clarifying things with them. If it is anonymous and it looks like there's a misconception, I would also try and clarify, because oftentimes a little bit of further training and re-education across the company can, A, there's benefits for that generally, but B, it can sometimes help to clarify where confusion might exist as to the propriety of certain conduct and avoid someone feeling unheard and then becoming a whistleblower. I think some whistleblowers are in it for money or because they were fired and hate their former employer. Others, really do have sincerely held beliefs that there was impropriety and that the company wasn't doing things correctly. They're not happy about that, and they want to raise their concern to try and address that impropriety rather than because they want to pursue a case. So I think, taking things seriously and ensuring there's follow-up and a plan in place makes a big difference. The other thing I'll just speak to briefly, is departing employees, which obviously, again, is coming up more frequently now as well. I think treating employees fairly on the way out the door as a general statement is always a good thing and is going to be helpful. But I think as companies are doing that, conducting exit interviews and obtaining information about potential compliance concerns or issues from departing employees is always helpful. If they identify none, maybe that's a statement that you can use down the road if they come back with something. If they identify issues, I think that's even better, because you'd rather an employee tell you on the way out the door so you can try and address things and evaluate the issue than nothing is said and either that employee files a lawsuit later or someone else does and you didn't know about the issue. And then I would also consider very carefully, you should, as best as possible, preserve documentation for employees, particularly, you have to preserve them if there's a known civil investigative demand or other issue and you have an obligation, like litigation exists, and you have to. But I want to talk briefly, and then we'll wrap up, about potential releases, because you can't require an employee to release False Claims Act claims. It doesn't work that way because those claims ultimately belong to the government and not to the employee themselves. So the employee can't actually release the claim even if he or she desired to do so. Where there is a little bit more flexibility, however, and where you can include, particularly if you're giving the employee a severance package, so they're going to be signing a document, a release can include a release of the potential recovery from False Claims Act actions. And to be clear, that type of release of the recovery won't be enforced in every state. Some states, some courts won't permit that, but we've certainly seen cases that do permit that as well. And so while you can't make the employee release the ability to bring the claims, you can sort of take the legs out of it by releasing or causing the employee to release the upside for bringing the claim. In other words, they won't be able to share in any recovery afterwards. So with that, I'm going to pause here. We've got a couple questions we responded to separately because I think they were more specific. We're certainly, our contact information is in the deck and obviously available online. We're more than happy to discuss with anyone any questions after the presentation ends, and want to thank you all for attending. And as a reminder to what Brett said, this is the first of a series of monthly webinars we're going to be doing all year long. One a month. It's not a huge time commitment. We hope it's a variety of different topics and presenters from the firm that we hope you all will find interesting and informative. So certainly encourage everyone who's on this line to attend the future webinars as well. And thank you very much for attending.
Thanks, everyone.